there is an appeal to the importance of sovereign immunity, of comity, of the undoubted fact that immunity derives from the sovereign equality of states and is an attribute of the state's sovereign authority, as my friend showed you, as per Lord Jones in the Supreme Court decision on the service issue in this case. Indeed, it is so. But it is equally an attribute of sovereignty that the sovereign can agree not to claim immunity. And it is critical for states to be able to obtain the benefits of commercial agreements, whether as buyer or supplier, whether it is boots for the army or a state-of-the-art military communication system. It is critical that states can effectively and prospectively agree that they will not claim immunity and that awards and judgments arising from their commercial contracts will be enforceable. The making of such an agreement is as much an attribute of sovereignty as is the immunity which is thereby given up in respect of that contract. And it's interesting just to have a quick look at a lecture that was given earlier this year by Professor Philippa Webb, who is, of course, Professor of Public International Law at Oxford and co-author with Lady Fox of the leading text on state immunity, in her Three Veridum Buildings NUS lecture earlier this year, which is going to be published as a paper in due course. It's in the bundle of further authorities, tab 12. And right at the back of the bundle, page 358. And this was a lecture in which Professor Webb has described internationally the developments in relation to moves towards there being a double waiver of immunity, in other words, of interpretation of submissions to arbitration, for example, as being waivers of both adjudicative and also enforcement immunity. But at page 358, she says at the top, but history has shown that when a state refuses to comply with an arbitral award and invokes its immunity from enforcement in ensuing litigation, private parties left with no means of enforcing the award. Recent empirical work on compliance in 260 ISDS cases where states were in breach of their treaty obligations found that 31% of awards remain unresolved. English judges have recognised the injustice of allowing states to escape their undertakings. In a case prior to the 78 Act, Duff Development, in order giving leave to enforce an award was set aside upon the application of the government of Kelantan. Lord Carson in dissent noted the palpable injustice involved in allowing a state to enforce an arbitration award if it wins the arbitration, but allowing it to prevent enforcement on grounds of immunity when it does not. Words matter. Consent to arbitration is a faithful commitment to upholding the award, even if it goes against the state. In my view, it does not lessen the dignity of the state for it to abide by its agreements, it enhances it. The second important principle is that when the state chooses to participate in the market, it should be accountable for its conduct. This choice and the reduction in legal protection that accompanies it is an attribute of sovereignty. My lords, the commentaries are all consistent in stating that the question of whether a prior agreement amounts to consent for the purposes of section 13.3 is a question of construction of the agreement, and we've referred to these in our skeleton. I'm not going to go to all of them. It's what is stated in Fox and Webb, Lady Fox and Professor Webb's book on state immunity, in Professor Andrew Dickinson, Ray Lindsay and James Lunam's work on state immunity at page 349, citing Republic of X and Saba for that same proposition, supplemental bundle 11, and also in Dicey, but in Dicey at paragraph 9-033, it's stated to be the approach in relation to submission for the purposes of section 2 of the Act. But in our submission, the approach must be the same and consistent in relation to the interpretation of a prior written agreement.
Can I just ask you a question about this lecture? Having set out her view, Professor Cox looks at, amongst other things, state practice in favour of double waiver. She looks at Switzerland at page 362. There she says that the highest court has repeatedly confirmed double waiver, but there's a jurisdictional nexus requirement, and there's also a tension between double waiver and the Implicit Convention. And then she refers to two cases, Arab Republic and X, where the court held the power of the execution flows from the power of jurisdiction. And 2 decades later, Egypt and Sinitel confirmed the waiver of jurisdictional immunity constituted an implied waiver of immunity from execution. Right. Is that consistent with the Moscow cases and the other cases that we've seen on the Swiss approach to enforcement? Seem to be positing something quite different.
No, indeed, my lord. I'm not. I absolutely stand by my submission that the substantive law of immunity in Switzerland is not relevant to the issue. No, and so
well, that may be the answer to my query.
And that was, and the judge specifically, and in our submission correctly explained why the substantive law of Switzerland in relation to that was not relevant, and it would be wrong in principle and entirely inappropriate for me to try and, as it were, jump on this point and try and use it. But
I was just curious. That's all.
No. I think there's a reference in one of the other commentaries as well to Switzerland being a double waiver. I think but
there it is.
There it is. Will you just give me a moment? That is all I wanted to say on the authorities.
Your next heading was relationship with the convention.
Yes. Thank you, Lord. My Lord, this is the easiest way of taking this is to ask your lordship to look at Fox and Webb. So this is an authorities bundle tab 29, which I think will be in your volume 2. Bundle page 928. Purpose, under the heading purpose, the SIA was enacted to codify the restrictive rule of state immunity, bringing our law into line with current international practice, and to enable the United Kingdom to ratify the European Convention on State Immunity 1972 and the earlier 1926 Brussels Convention and 1934 Protocol relating to the immunity of state-owned ships. The two purposes that, just pausing there, the two purposes that are relevant are in this context are, so the codification of the restrictive rule of state immunity and the enabling of the United Kingdom to ratify the European Convention. Let me, if I may, touch on each of those in turn. First, as to the relationship between the State Immunity Act and international law, this was addressed by the Court of Appeal in the Prestige in a judgment given by my Lord Justice Phillips together with Lord Justice Males and Lord Justice Popperwell. I don't think I need to turn it up. It's at tab 19, where the judgment quotes, in fact, actually the relevant part of the judgment is quoted in the, sorry, at tab 19 in the Al-Masariya decision. But can I just summarise what the Court of Appeal said? I don't think it's contention. The Court of Appeal set out in that passage, first of all, the provisions of the State Immunity Act are to be construed against the background of the principles of international law. Second, that includes the restrictive doctrine of state immunity and the distinction between sovereign and non-sovereign acts. But third, the question is still ultimately what the provisions of the Act mean, and while international law is relevant to that question, it is not determinative. The importance of that is that, in particular, the exceptions to immunity in the Act might be wider than that provided for under international law. On the second purpose, so that's the relationship between the State Immunity Act and the European Convention, this is again addressed in Fox and Webb. If you go on now to page 931, under the heading Relation of the State Immunity Act to International Conventions, the European Convention on State Immunity in 1972. In its original form, the bill followed closely the structure of the ECSI, and both Lord Wilberforce and Lord Denning initially expressed concern that there was a risk that the proposed legislation represented a more restrictive line on state immunity than is generally expressed in international law or in the Court of Appeal's decision in Trentex on appeal at the time to the House of Lords. Amendments, however, were made to enlarge the scope of the statute beyond that of the European Convention in the course of the bill's progress through Parliament, with the result that, and the relevant one is Roman 3, the provision relating to arbitration agreements was extended to permit enforcement of foreign arbitral awards by Section 9. 4, the Act provided a general right to execute a judgment against a state on state property in use for intended for use for a commercial purpose. Now, those are obviously material changes of relevance, both to sections 9 and to section 13, which explains why those sections are in materially different terms to the equivalent provisions of the European Convention, which are Articles 12 and 23. My Lords, Libya also sought to rely on the European Convention on the issue of service when it went to the Supreme Court. And can I just show your Lordships what Lord Lloyd-Jones, with whom Lord Burrows and Lady Arden agreed, what he said about this. This is Bundle, Volume 1, Tab 17. At page 488, bundle page 488, paragraph 48, a significant difference between the SIA and the ECSI is that the latter does not permit measures of execution against the property of the state, except where and to the extent that the state has expressly consented thereto in writing in any particular case. In particular, the explanatory report on the ECSI states at paragraph 51, in relation to Article 12, which relates to disputes subject to arbitration, that it should be made clear that proceedings concerned with the enforcement of arbitral awards are outside the scope of the convention and governed by domestic law and any international convention which may be applicable. So the different language of the provisions of the European Convention is not going to be of assistance to your lordships in relation to the particular issue in this appeal. Not only was the whole regime for the enforcement of arbitration awards against state property different in the Convention, the specific provision on waiver in the ECSI consent in the State Immunity Act is in different terms. And the attempt by Libya in its arguments to get support for its arguments by referring to the requirement in the European Convention that consent be express, in our submission adds nothing when one is concerned with a written prior agreement. And the requirement for writing is obviously in the section. As my Lord Justice Lewison made the point to the known friend, once you have interpreted the terms of a written agreement, then that meaning is express. And indeed, as I think my Lord Justice Phillips said, that is an issue which is also discussed in the infrastructure case and in the High Court of Australia decision, and is also discussed by Lord Gough in the Pinochet case. We've dealt with this at paragraph 27 of our skeleton. In Pinochet, Lord Gough explains that the reference to a written agreement in the Act is a reference to express agreement. That is to distinguish it from and to exclude implied agreements. So that's simply not a matter of any, that adds anything to the analysis for the purposes of this appeal. My Lord, next, the Swiss law arguments. Libya in its skeleton identifies what it says are three errors in the judge's approach to the issues of Swiss law in the case, and my own friend developed the argument in relation to this. So that is whether the principles were common ground point, the Moscow Center argument, and the good faith point. Let me deal with each of those in turn. For the common ground point, your lordships need to just understand a little bit about how the Swiss law came to be in the form it was for the judge, because I want to show you lordships that the point that's now being taken as to the suggestion that the judge did not have common ground is not correct. Could we go first, please, to Supplemental Bundle tab 12. Which is Mr. Brocklesby's fifth witness statement. The solicitor then with conduct of the matter on behalf of General Dynamics. And at page 68, paragraph 74, he notes that the contract is governed by Swiss law. Paragraph 75, referring to the Commercial Court Guide and FS Caro regarding the flexibility that now exists as to the form of evidence on foreign law. And then paragraph 76, he says, without waiving privilege, I can confirm that I have liaised with Dr. Christian Oetker, a Swiss law qualified lawyer and partner in the law firm Vischer AG, based in Basel, Switzerland, regarding the Swiss law approach to interpretation of contracts. Mindful of the claimant's duty of full and frank disclosure, I draw to the court's attention that Dr. Oetker acted as counsel for the claimant in its ICC arbitration claim that led to the award against the defendant. He is therefore not an independent expert. From my discussion with Dr. Oetker, I have set out in paragraphs 1 to 8 of Annex A to this witness statement extracts of relevant law and leading authorities in relation to interpretation of contracts under Swiss law. And sorry, I should have said that the reference there in paragraph 76 to pages 630 to 634 of NB5 is a reference to a short memorandum produced by Dr. Oetker, which is also in this bundle at tab 26, but we don't need to turn it up. And then paragraph 78, Mr. Broxley said, I recognise that it's a matter for the English court to reach its own conclusions on how to interpret and apply the relevant principles set out in paragraphs 1 to 8. However, my understanding is that in broad terms, the Swiss law approach to interpreting contracts involves ascertaining the true and in common intention of the parties, and that in order to do so, a Swiss court would consider the following, and he then sets out those principles. Starting point, well, perhaps I can ask your lordships just to read.
Yes, well, the judge sets those out.
And the judge said, indeed, and the judge, those are the ones that the judge set out, indeed. Then, can we then next go to tab 13?
He says at 79 that he's not aware of any principle of Swiss law in which commercial contracts with the state would need to be interpreted differently from commercial
Thank you,
contracts.
Lord. I should have drawn attention to that. And then tab 13 is sixth witness statement. This was filed shortly before the interim charging order hearing, and at paragraph 35 on page 87, he said, at paragraph 76 of my fifth witness statement, I confirm that I've spoken with Dr. Christian Oetker of the law firm Vischer, based in Basel. Paragraph 78 then provides a brief summary of the Swiss law approach to contractual interpretation, and Annex A provides a summary of its general principles of that subject. I confirm that Mr. Oetker has, in February 2023, reviewed those passages of my previous statement, and he is not aware of any subsequent authority or principle that has materially impacted upon the summaries provided in my previous witness statement. Then please, can we go tab 14, now to the third witness statement of Ms. Zacaroli for Libya, to which my learned friend made reference. And can I just show you some other parts of that to see how this issue went? First of all, paragraph 38 on page 92. She noted that Libya had engaged a Mr. Nessi, a Swiss qualified lawyer. And then in paragraph 39, she said, Mr. Nessi reviewed, 1, paragraph 74 to 82 of Broxby 5, covering Mr. Brocklesby's summary of the Swiss law approach to interpreting contracts. 2, Annex A to Brocklesby 5, containing extracts of relevant decisions in leading authorities in relation to the interpretation of contracts under Swiss law. 3, relevant Swiss legal authorities. 4, the memorandum by Dr. Christian Oetker regarding the Swiss law approach to interpretation of contracts. From my discussions with Mr. Nessi, my understanding is that in his view as a Swiss qualified lawyer, the analysis on the principles of contractual interpretation provided by Dr. Oetker is correct. Similarly, that sentence, my learned friend didn't read to your lordship. He started with the next sentence. Similarly, Mr. Nessi has confirmed to me that the legal authorities contained in Annex A are decisions of the Swiss Supreme Court. It's the first sentence which is important, confirming that Libya's expert agreed with Dr. Urtica in relation to the principles as summarised in Mr. Brocklesby. Then Ms. Zacaroli goes on in the line just above the subparagraphs. I set out below my understanding of the Swiss law approach to interpreting contracts, and then that is set out over four or five subparagraphs. In other words, we do not and have not been able to discern any material difference between what Ms. Zacaroli says is her understanding in those subparagraphs with the summary in Mr. Brocklesby's witness statement, and indeed my own friend did not suggest to you, and Libya have not suggested in their skeleton, that there is any material difference between the two. And more importantly, in our submission, and this is the basis upon which the judge proceeded, there was in fact agreement from Libya's expert that what had been set out by Mr. Brocklesby as a summary that was approved and agreed by Dr. Urtica was correct. What then is Libya's point? Well, their point is based on what Ms. Zacaroli says in paragraph 41 of her statement. And again, bearing in mind that this comes after setting out an understanding of the principles of the Swiss law approach to interpreting contract. She said, the correct interpretation in light of the above Swiss legal principles is a matter for submission. But I note here that the position set out in Brocklesby 5 is not agreed by Libya. Well, absolutely correct. The correct interpretation of the clause in the light of the Swiss law principles was a matter for the judge, not for the experts. And of course, the disagreement between Libya and General Dynamics as to the application of it and as to how clause 32 should be interpreted was, of course, not a matter that was agreed. The judge was, and then, finally, in terms of references, if we could go to tab 1.
So your submission, I think, is that what Ms. Zacaroli is really disagreeing with is not what Mr. Brocklesby says in paragraph 78 or 79, but what he says in paragraphs 81 and 82 about how he applies those principles to the clauses under, or the clause under consideration.
Exactly so. And just to reinforce our submission that the position in relation to the principles was common ground and the judge was right to proceed on that basis, if you look at Libya's skeleton below tab 1, page 9, so this is Libya's skeleton, and they said the governing law of the contract is Swiss law, and so on. And then last sentence of paragraph 15, there is considerable common ground between the experts, Zacaroli 3, and then sets out those points by reference to both to, you will see, both to Brocklesby 5 and Zacaroli 3, looking at the references for each of those subparagraphs. And nothing there said to the judge to indicate that there was any material disagreement as to the applicable principles for interpretation of contracts under Swiss law.
Yes, and 15.2 specifically agrees with Brocklesby 78A. 15.3 specifically agrees with Brocklesby 78B. And 15.4 specifically agrees with Brocklesby 78C and D.
And then your Lordship will also then just note paragraph 16, express or implied waiver of state immunity is possible under Swiss law, but it must clearly express the state's intention to do so. See the academic commentary of Professor Koskowitz. And 2 points I make about that. I'm going to come back to Moscow Centre, but first, no reference to Moscow Centre. Secondly, no suggestion that that is a principle of contractual interpretation rather than a reference to a matter of the Swiss law of state immunity. And then the judgment addressed the Swiss law principles at paragraph 11, core bundle 26, page 80. As your Lordship has noted, quoting from Brocklesby 5's summary and then saying that that was accepted by Libya, and accordingly the judge was correct to say that and correct to proceed on that basis. And then the judge in paragraph 12 refers to the Swiss substantive law point. Some reliance was placed by State of Libya on a proposition of Swiss substantive law that a contract which is alleged to waive state immunity as a matter of Swiss state immunity law must be clearly expressed. In my judgment, the role of Swiss law in this dispute is to provide the rules by which the meaning of the agreement is to be ascertained. Once that exercise has been completed, it becomes a question of English law whether the parties' agreement takes effect in England as Wales as such a waiver. As to that, as I've already said, and as is common ground, no special words are required in order to satisfy the written consent requirement of the State Immunity Act. In my submission, the judge's treatment of the Swiss substantive law matter was impeccable and correct. My Lords, the reliance now on Moscow Centre is doubly misplaced. Obviously, I've trailed, and indeed the court asked my own friend questions about whether Moscow Centre is simply a part of the Swiss substantive law of immunity rather than a contract principle, and it clearly is. But the first point is that the criticism of the judge for not referring to Moscow Centre is really a bit rich, because Libya didn't rely on it below. It wasn't referred to in its skeleton. It wasn't referred to in its oral submissions. But anyway, even if Libya had done so, it would have obviously attracted exactly the same answer, rightly, as he gave to the limited reliance that had been placed by Libya in reliance on the article of Professor Kotkowitz. The answer to your Lordship's question about whether the Kotkowitz article that's referred to in the body of the Moscow Centre judgment is the same article as relied on, we think not.
I think actually it was my Lord Justice Zacaroli
Sorry,
asked that.
It was indeed. Apologies, my Lord. We think not, because the dates are different. And in fact, if in the Professor Kotkowitz article, which was relied on by Libya and which you have in the bundle, in footnote 4 of that article, there is reference to another Kotkowitz article, and the date of that that's given does fit with the reference in Moscow Centre, but we don't have that. But for our purposes, in our submission, all of this is by the by. The short point in relation to Moscow Centre is that it is apparent from the judgment itself and from the Kotkovitz article that what is being discussed are aspects of the Swiss substantive law of immunity and therefore irrelevant. And indeed, as was noted by our lords, in any event, in Moscow Centre, the governing law of the agreement was Luxembourg law. So that, again, all fits in terms of establishing the irrelevance of that case to any question of Swiss law principles of construction of contracts. Then, my lord, can I deal with the good faith point? This point, as best we can understand it, is a suggestion that the judge adopted the, as it's described in Libya's skeleton, the wrong approach to good faith under Swiss law, and my own friend put it rather higher in his submissions earlier in suggesting that the judge went on a frolic of his own in relation to a requirement of good faith under Swiss law. The point is really not really very interesting or significant, and has been blown completely out of proportion. As your lordships have seen, under Swiss law, one first tries to find a subjective consensus as to meaning. But if the court cannot do that, then it performs an objective interpretation as to what the parties would understand the clause to mean in good faith. The judge noted that there wasn't any evidence as to precisely what good faith meant, but concluded that he should arrive at the meaning that a reasonable person with knowledge of the surrounding circumstances would conclude was intended. That's paragraph 13 of his judgment. And that is what he did. And in our submission, he can't be faulted for doing so. Now, as we have said in our skeleton argument, paragraph 35, it is clear from the Swiss law materials that a good faith interpretation is simply an objective interpretation. And I can give your lordships the references. I wasn't going to wade through them, but the Basel commentary on the Swiss Code of Obligations at supplemental bundle 22, page 294, at paragraph 13. The objectivizing approach is based on what reasonable parties would have understood from the present wording. And it's actually clear from the preceding page at paragraph 11 that the commentary is referring to a good faith interpretation. And then in the same commentary at paragraph 77 on page 307, the reference to good faith, or as it is called in other formulations, the will of reasonable contracting parties. So the judge wasn't placing any wider or different reliance on the good faith principle. He was simply doing so as supporting the objective interpretation, which is the approach that he took. And we don't seek to say that there's any different or place any reliance on the good faith aspect, and this point simply goes nowhere. You will just give me one moment to take stock. Your Lordship, just allow me a moment. My Lords, there's so one last point which I was going to deal with. It maybe I can deal with it very shortly, but can I just give Your Lordships a couple of references, which I'm grateful to Mr. Riddell for passing me in relation to points that Your Lordships asked me about. Fox and Webb also refers to double waiver in Switzerland, though not relevant, but I'll just give you Lordships a reference. It's Additional Bundle of Authorities, tab 30, page 935. And then in relation to, I said to my Lord Justice Phillips that there is widespread support for an arbitration agreement by itself resulting in a loss of adjudicative immunity, and the references are in our skeleton at footnote 23. Call bundle page 63. My Lords, you will have seen in Libya's new skeleton that apologies. Libya's new skeleton, paragraph 61, on core bundle page 36. They say, in view of the above, when interpreting an alleged contractual waiver of immunity, a term which is commonplace in many commercial contracts with states, it is appropriate for the court, on the basis of Swiss law principles, to have recourse to market practice as to the forms of language which are deemed to effect waiver. Now, as your Lordships will have apprehended from our skeleton, we were concerned and unhappy about this for rather obvious reasons. If this was seeking to introduce on appeal an actual suggestion that there is a market practice in relation to the form of wording. Renfern hasn't, and your Lordship will see in paragraph 37 of our skeleton, we both say that that is not open to Libya on appeal, but in any event, can't be made out on the basis of the sporadic reference to model clauses in.
Normally, if you were going to allege a market practice, you need to call some evidence about it.
Exactly so. Exactly. If that is still maintained, then our position is and must be one of objection, because there is no doubt that had it been contended by Libya at first instance that there was a market practice in relation to wording, we would have undoubtedly wanted to seek expert and adduce expert evidence in relation to that. There would have been an anterior question as to exactly what the market is. And is this suggested in relation to all commercial agreements with all states throughout the world, or said to be something particular in relation to defence agreements? Unclear. But, my Lord, it hasn't been developed in that way orally. There was just the reference to the model clauses in the couple of textbooks, which, as I say, are more recent. And so, my Lord, it may be that actually this point has rather retreated, if not disappeared. But your Lordships have our position on that. Unless I can assist your lordships further.
Thank you very much. Mr. Lissack.
My lords, first of all, the market practice point, it's a question of labelling. We don't wish to continue to raise the false flag that it represents, even if we hoisted it first, and so we leave the matter there. In reply, exercising all due restraint, we have a handful of points to make. First of all, this. We both agree how simple this case is, and as is so often the case where a case positively bristles with simplicity, it can take an awfully long time to unpack. Can I dial this right back to the very essence? There is a two-stage approach to determining the meaning and effect of clause 32 of the contract. Stage 1, construction under Swiss law. What does the clause mean? Stage 2, threshold under English law. Does it meet the test for written clear words as required by the State Immunity Act? It is obvious that the English law must set some kind of statutory threshold, because the SAA, for example, requires the consent to be in writing. So the clearest oral agreement, whether express or implied, would not be sufficient in English law, even if it were sufficient in Swiss. If the conclusion under Swiss law is that clause 32 was not sufficient to amount to a consent to execution, it would fail the SIA threshold. If clause 32 was sufficient to amount to a consent to execution, it would still need to be written and clear for the purposes of meeting the SIA threshold. Either way, as part of the Swiss law construction, it must involve Swiss principles of contractual construction as applied to alleged waiver of immunity clauses. Otherwise, the exercise would have no context. That is not the same as applying any further Swiss tests. For example, that the agreement must be made by way of notarized text or notarized by the relevant ambassador and so on. All we're seeking to do here is to apply the Swiss rules of construction, nothing more, nothing less.
Can I just ask you something? You said if interpreted in accordance with Swiss principles, this was consent, it would still need to be clear for the purposes of the State Immunity Act.
Yes.
So that could lead to a situation in which, let's suppose, a Swiss Supreme Court says, yes, this means consent to execution. You bring the Swiss judgment over here, and the English judge says, well, that's not good enough for the State Immunity Act.
That's correct. Second point, structure of the State Immunity Act. And this goes back to a point that was put to me originally. My learned friend then dealt with it as well, about the language of the State Immunity Act, the fact it doesn't include the word execution. I just wonder whether it might be useful to look at it. It's Authorities Bundle, tab 1, as you know. If I could take you, please, briefly, to page 12, I'd be grateful. And it's just to make this point. If we look at section 13(2)(b), it reads, the property of a state shall not be subject to any process for the enforcement of any judgment or arbitration award in an action in rem for its arrest, detention, or sale. 13(3) speaks again in terms of process, not prevent the giving of any relief or the issue of any process with the written consent of the state concerned, etc. 13(4) speaks in terms of process in 3 places. It seems to us, with respect, that process could be an alternate to the word execution. And either way, process may well be broader than execution, but it plainly envisages steps to be taken in furtherance of the enforcement of any judgment or arbitration award. Therefore, whilst I accepted before, and learned friend didn't demur from this, no one can, that the State Immunity Act does not in this part expressly include the word execution. The concept of process that it is replete with acts as a cipher.
But the process is described as process for the enforcement.
Yes. Thereby further flagging up, and I'll make this point later, but I'm grateful to my Lord, further flagging up the fact that it is different to and additional to the question of enforcement.
Why?
Because you have enforcement, and then you have the issue of any process attendant upon it.
Enforcement is going to involve some process, isn't it?
Well, yes,
However you analyse it.
yes. I'm not going to detain you arguing about that sort of point at this time of the day. No, my Lord is of course right. But what this is aimed at in our respectful submission is it envisages, first of all, enforcement of any judgment or arbitration, then a process to achieve it, which we submit can only mean, or at least include, execution.
How do you enforce a judgment without executing it?
Well, you can enforce it by the first stage is recognition.
Yeah.
The second stage is enforcement, which may be, for example, an order for the payment of money. You don't need execution to do that. There may be a series of
If the debtor doesn't pay, don't you
well,
want
of
to
course,
do
there's
something?
there are the subsequent steps, of course, which constitute execution, may constitute execution, may constitute all sorts of other.
So enforcement doesn't really get you any further forward than the award, because by submitting to arbitration, the debtor has already agreed to pay whatever the arbitrator has awarded, and so by recognition, the debtor still is bound to pay what the arbitrator has awarded. But on your analysis, there's nothing that can be done about it.
Well, there is, because what happens is what happened in this case, that you issue an application, the arbitration process comes to an end with the award. The battle then moves to the courts. In court, you apply for an order under section 101, subsection 2 of the Arbitration Act. That gives you a suite of orders exactly as was obtained in this case. And then you decide what you do with it. Do you move forward to execution? In other words, to charge, for example, as here, a property to secure payment of a debt if it is unsatisfied or not?
Enforcement means less than execution in relation to arbitration, which is your point, I think.
Yes.
And it's having a different meaning to be when it sits before judgment as opposed to when it sits before arbitration. Can that be right?
Well, it depends. I see the point my Lord makes. Thank you. It depends entirely upon the sequence. So that if the arbitration award stands as a judgment in an action in red, then it would be of equivalence. But otherwise, it would have a different meaning. Yes. Can I move on to the scope of ground one, please? Learned friend started with this point, making the point by reference to the submissions made in the court of first instance, where he was there and I wasn't, so I defer to him. Sorry?
I wasn't there.
You were there for the argument on petition to appeal.
Oh, for the permission to appeal.
Yes.
Sorry.
All right.
Sorry, I thought
You were there.
I was there.
Yes. Well, now we've established that. That's good.
Common ground.
Yes, marvellous. What a nice note to end on. But another friend took you to the submissions to make the point that the argument that we seek to run now under ground one is in some way more expansive or developed than the argument.
May or may not be, but he doesn't object to it.
Well, I was going to say that. Thank you. I'll move on. Thank you very much. Infrastructure services in the Kingdom of Spain. I do apologise for failing to deal with this in my note to do, and I've got two passages I want to invite your attention to, and I'm sorry I didn't pick it up in my keenness to finish. This is in the Supplementary Authorities Bundle, tab 6. Page 311. That is, of course, particularly well known to my Lord Justice Phillips. We submit that this case is of no assistance to GD UK. First, as GD UK must acknowledge, and as is the case, it related not to waivers under Section 13, but rather to waivers made by treaty or convention, which are negotiated in a different way from bilateral contracts between states and commercial parties. Second, and in any event, as a matter of substance, the infrastructure services case is entirely consistent with the Libya's case here. Can I take you please to page 310? And respectfully, not too impertinent, remind my lords of paragraph 84 and picking it up in the pre-penultimate line of the of paragraph 84 after citation from the speech of Lord Gough, which accepted the proposition, my lord continues, that waiver of state immunity by treaty must always be express. And then over the page, a submission to the jurisdiction is here regarded as an express rather than an implied waiver of immunity or agreement to submit to the jurisdiction. And then speaks in terms of consistency of the act and so forth. I need to remind you of all that. And then this in the next paragraph. In the light of the foregoing, it appears to me to be clear that in accordance both with international law and with the law of this country, which on this point reflects international law, a state's waiver of its immunity by treaty must, as Dr. Collins submitted, always be express. Indeed, if this was not so, there could well be international chaos, and the courts of different state parties to a treaty reach different conclusions on the question whether a waiver of immunity was to be implied. And then we would respectfully align that with page 92, so paragraph 92 on page 314. Last sentence. If the express words used amount on their proper construction to an unequivocal agreement by the state to submit to the jurisdiction, that is sufficient to satisfy section 2.2 of the SIA, even if the words submit and waiver were not used. And we take from that that the interpretation in the context of that case of express as unequivocal is consistent with our approach. In contrast, the words in clause 32 are far from being unequivocal. To be unequivocal, there were many formulations which could have been used, but none were. Next point, ICSID. My Lord Justice Phillips helpfully referred more than once during the course of our submissions and in Learned Friends to ICSID Convention Articles 53 to 55. And I don't wish to make more of the point than I properly should. I adhere to the submission I made earlier on with respect that we don't need to go there. There's common ground that under Swiss law, the context to a contract is relevant to its interpretation. And of that there is no doubt. So whether you look at the ICSID Convention or Law Justice Moorbeek in Svenska, or all of the examples of effective clauses in the past, you get to the same answer, which is that clause 32 did not come close to being sufficient under any known law to us, mainly Swiss, or by extension under English law. Sixth, Moscow Centre. In our respectful submission, the one I'm looking at the time, Moscow Centre is of importance because we need to satisfy the court that the case applied Swiss principles of contractual interpretation and not their equivalent of the SIA or PILA. To put it briefly, as to this, GD UK has two objections. First, it says that the agreement in question was governed by Luxembourg law. But as I've said already, there is no suggestion that there were any different principles applicable. There is no indication in the judgment of the Swiss Supreme Court that the principles under consideration were any different from those under Swiss law. There was no consideration at all of Luxembourg materials in the judgment, and indeed the governing law is mentioned just once in passing. Secondly, my learned friend says that Moscow Centre was substantive law and not contractual interpretation. And as to this, my learned friend has not referred to any of the, anywhere in the reasoning of the Moscow Centre case, which is said to deal with Swiss substantive law at all. My learned friend has not even sought to identify what the Swiss substantive law is said to be. And as my Lord Justice Phillips pointed out correctly in our respectful submission, if I may be so impertinent to paraphrase, the difference between construction and so-called substantive law at this point becomes somewhat illusory. It was and remains common ground that Moscow Centre represents the Swiss law on construction of contracts. And whilst my Lord Justice Lewison has very fairly pointed out that we have asked for the court to reconsider the evidence, it is just not open to my learned friend or indeed to GD UK to withdraw their own evidence as to what was Swiss law or which Swiss law principles and authorities stood for. There's certainly been no evidential recanting of any sort from Mr. Brocklesbury or his successors. I'd invite you just to note, but I don't have time to take the court to it, Supplementary Bundle, tab 15, page 103, and note the heading, A Contractual Party's Waiver of Rights, to the section in Mr. Brocklesbury's evidence to which my learned friend points. And follow that over to 29D on page 104. We respectfully submit that my learned friends are stuck with Moscow Centre as they are with the article that was cited in addition to it. And it lies ill in their mouths now to seek to disavow their own authority, which their client had previously relied upon as setting out the position in Swiss law. Saba Shipyard, as the court rightly noted earlier, the guarantee in Saba was governed by English law. It was therefore appropriate to apply the English law principles of contractual construction to it. Those principles are set out in A versus the Republic of X. There are two things which unite the two cases, Saba and A. First, that the contracts in both were governed by English law. Second, that again, as the court has rightly pointed out to my learned friend, both had extremely clear waivers of immunity as to execution. Neither of those factors is present here. And we are, of course, dealing with a Swiss governed contract, the wording of which is far from clear. On execution and enforcement, and this is my last point, may I just invite the court to note, for later reading if the opportunity arises, a passage from Fox and Webb, Authorities Bundle, tab 29, page 931, where they explain the bills, that's the State Immunity Act's bill, as a bill to legislative history, setting out in clear terms the same distinction which is recognised by Lord Justice Morbick in Svenska, and which we make here. We began with it, and we end with it. My lords, those are our submissions in reply, unless there's anything you would wish me to deal with.
Just one question which I probably ought to have asked before, probably doesn't matter. I've assumed throughout this that the contract that we are dealing with, although governed by Swiss law, was written in English.
Yes. Was.
No,
Can I just check with my friend? It's certain we've got an English copy, but then so may I just check that it was originally written in English or not just a translation? It was it? Yeah, it was. My friend nods.
Thank you.
Thank you.
Thank you very much for your very interesting submissions. There's quite a lot to think about, so we will reserve our judgment. You will get a judgment in draft in due course. It will come subject to a strict embargo, which must be observed. And it will be your opportunity to correct our English, but not our reasoning. And we would hope that in the light of the draft judgment, you will be able to agree a form of order disposing of the appeal.
Thank you.
If you can't agree a form of order, make short submissions in writing, and we will make the form of order that we consider to be appropriate.
And may we thank the court on behalf of the bar for those instructing us for the capacity to, in a busy end towards the long term at the end of a year, to spend as much time pre-reading as you obviously have. So we're very much obliged. Thank you.
It's our job.
Even so. Thank you.